Hello, everybody! Excited utterance here, and happy Hump Day to you, and happy Justice Day! Justice for Sarah Boone! Justice for Coburger! Justice for everybody! Justice for all! Justice means justice! Yes! USA! USA! Australia! Australia! Everything! Yes, I've had my coffee. I'm having my coffee. It may have a few too many shots in it. Whatever. Yeah, okay. No, I haven't found my cat yet. I'm trying to cheer myself up. Whatever, it's fine. Hi, everybody. Hi, everybody. How am I? Good. Start the day in a happy way. Guess what? Sarah's getting her shackles off. Such a great day. And the other cool thing is that Court TV, they're keeping this thing up of waiting until I get out of bed, till I rise out of bed, until they stream the Sarah hearings, just for me. So I don't have to get up in the middle of the night. I wake up and you know what? Mr. Darley, here he is. Hang on. Mr.
Hey.
Darley's like, hey. He goes to me at 7 a.m. this morning. He goes, are you going to cancel your Sarah stream? And I'm like, oh, look, it's a bit early for that. It's a bit early to make that call. And then, ye of little faith.
I know.
Ye of little faith. What, at about 8 a.m. my time?
Yeah, like an hour ago.
An hour ago, he goes, oh, well, looky here. Looky here. They're streaming it now. And I'm like, wow, there you go. Looks like.
And I even caught it like 30 minutes late, too. Normally, I'm quicker on the draw.
Yeah. They're streaming it now, and no one else is streaming it. It's like, well, that's because they waited for Miss Heller, because Sarah must have put in a good word for me.
Yes.
They put in a good word for me. No more shackles. No. Hey, Murphy Taffy.
Free at last. Free at last. God almighty, free at last.
Take shackles off my feet so I can dance. All right. What's this, Flashman? I agree with you now on Kraynick. That's all I say for now. He's a dick.
Well,
Kraynick's a dick. Well, he's a wolf in sheep's clothing, is what he is.
And a senator.
He acts really kind and mild-mannered and like he's trying to help her. And he's doing all this for the cameras and for the records, but he's actually tying her hands, and that's a good metaphor, I suppose, tying her hands at every opportunity. He's trying to make it more difficult, but it's not his fault, because he knows full well that the jail is not going to facilitate her in any manner whatsoever. But that's not his fault. No. Right. Hello,
well,
Jane K.
I did what I could.
Yeah, I did what I could.
Tried.
Snibbles. Hello, Snibbles.
I'm just a simple judge. I can't control what the jail does.
Yeah. All right, let's get straight into it, guys. Let's get straight into it. So, the moment. Hang on, I'm just going to backtrack 2 seconds because we missed the great moment. Well, not that.
God, that's so creepy.
I hate that thing. Here we go. The memento.
Free at last. Free at last.
Look at that.
Get your cuffs off me. Get your pink cuffs off me. How dare you assume my pronouns?
There she goes. Alrighty.
Oh, she even has a pink folder, too.
I noticed the pink folder the other day. Yeah.
It'd be really funny if she took a run at the judge right now.
Yeah.
First second of freedom. Yeah, does that whole leaping over the bench thing?
Yeah. She would get shocked though, because she's still got the shock.
Yeah, but I don't know. I wonder how far she could get.
And check out the giant sheriff next to her.
Oh boy. You do not want to mess with him.
Don't give her any luggage. Okay, hello, why can't we hear you, dude?
There's no sound for a little bit.
Right.
So you'll want to skip forward.
Hello. Hello.
Law and Crime did Boomer the Tellus trial today as well.
Oh, really?
Yeah.
My intention for this afternoon is to have Ms. Boone proceed first with anything that you'd like to tell me.
Okay for me.
I will hear from the state if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time. Okay? Yes, ma'am.
Have a seat back there.
Wherever you feel most comfortable.
Just sit back there while she.
Okay, thank you.
Until you're right here.
Thank you, ma'am. Ms. Boone,
You want to sit on my lap?
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTV and the Orlando Sentinel.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th.
Hey,
by
Jesse.
WFTV. It was sent to you by U.S. mail at the
Okay,
correct
now they changed the
legal
audio
mail
setup.
address on August 12th.
Yeah.
And the Orlando Sentinel's motion to intervene
It's
and
going to
notice of
require some
joinder
playing with.
was filed on August 13th.
Better.
And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies. Oh, perfect. All right.
Hey, Wookie.
That's why I was saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not? Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
Cases that I know are in a report by part-time. I have extra copies of those.
The microphone.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. Steve, do you need a copy of them? All right, thank you, sir.
Yeah, don't hide them from Sarah Boone. She's not good at hide and seek.
No.
She's not good at the seek part.
No. So wait, who is this lady?
It's okay. That was okay for me, but the two different news outlets, a local news outlet, maybe a Fox affiliate, filed a request to be able to see the evidence.
Right.
To see Sarah handle the evidence.
Yeah.
To prepare her case. And then a secondary media outlet joined their motion for coverage.
Yeah.
She is the representative from the main one that is arguing for the media outlet's behalf.
So they get to be in court arguing for that.
Yeah.
Okay.
They're like a third party intervener.
It's a dumb motion, Flash fan. Yeah, right. I know.
Well, I won't spoil it.
No. Hello, Nikki. How are you? Nice profile pic. Aren't you looking cute? Well, I don't actually, Caleb. I don't think anyone should see those hearings. No one should have to. Yeah, that should be private. If it were any other attorney, that would be private.
Yeah, Sean was kind of annoyed at it when he saw it today. Yeah, because it's strategy. It's case prep. It's
just because it's her. They want the salacious video of her handling the suitcase.
Yeah.
Of course they want to see that.
See her crawl into it.
Yeah.
If I may say.
Hey, Eamon.
One of my discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that? I would have already had this and not had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this.
Can you turn it up?
So
I'll try.
I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing.
What?
It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
Case law.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission.
Please.
You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The only thing that I was provided was that there's a provision of witness list from the state
Hey,
and
David.
then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Okay?
Why are they being mailed to her?
Ma'am, with regard to,
I do wonder if mail
It's the
was
first time I'm
late.
seeing each one of these documents.
I understand that. They were filed August 12th and unfortunately this morning due to an issue with the e-portal.
I wouldn't have internet access.
Okay.
She doesn't have internet access.
They were sent to you via US mail as well.
Yesterday?
Yes.
Yesterday? They were sent out
You're not wasting the
yesterday.
court's time. You can feel free to review those at this time.
He just said she was wasting the court's time.
What? Hang on.
Pull
Wait.
back 10 seconds.
At this time. So you're not wasting the court's time. You can
Oh.
feel free to review those
Oh.
at this time.
Sorry. That was still kind of passag, but
It was.
Is this the case law you're referring to? State versus Smith?
well, it's not the court's fault. The
I
US
believe that
mail
those are the
doesn't work.
circuit court opinions that are referenced in WFTV's motion, which cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
All of these services? And these are mine to take? Thank you.
So now she gets it. Fantastic. That's really useful for today.
Like, this judge is making so many. At least, I don't know. Maybe they'll just say it's harmless error, but it's really getting irritating.
Her Sixth Amendment rights are being shat on. I am sick of this. Shat on.
At least Ty was able to prepare, well, at least for his first trial, outside. I mean, he had the internet, he had resources.
She's not a danger to society, for God's sake. This is ridiculous. If she must be pro se, let her out. Let her prepare.
Yeah, house arrest, ankle monitor.
This is so stupid. Mailing things to her down the street.
Can't they get like, yeah. Well, I mean,
Charles,
she
it's
probably
so
shouldn't
good
get
to
a
see you.
probably shouldn't get a job at like an airport or something, but
No, not an airport.
yeah, no.
Yeah, Ty had an ankle monitor.
Oh yeah. Oh
Yeah.
yeah.
Oh, yeah.
And drug testing, house arrest.
Mm.
That's why he's in jail, because he was late for
Yeah,
his drug test.
KLF. It would be great for her to have an email address, but she has no internet.
Have any opportunity to look up any case law of my own in the meantime, so.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been previously scheduled?
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court, other than sensationalism and exploitation, purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many, many ways globally.
She's not
again.
wrong.
And I see on on the motion to intervene for WFTDs, my question is, why is this an important criminal proceeding? And why do they need to have it monitored? I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case. It is my understanding that some information is not able to be publicized due to privacy. And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case. And I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I'm asking for their minutes to be closed.
Okay.
This is an active, ongoing investigation case.
That is a good legal argument.
You think?
Anything else, ma'am?
That's what Sean said.
No, Your Honor.
Well, it is. It's just
Do you have
really
any
wordy,
position
and
on Ms. Boone's closure motion.
It wasn't.
she's right.
All right.
It wasn't
Mr. Gay?
argued eloquently,
It wasn't argued eloquently. Yeah,
but
Thank you, Your Honor.
she's right.
Yeah.
I think Ms. Boone's argument really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as Your Honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. Careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public. I think heightened public attention only increases the need for transparency.
Oh, please.
Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has.
Oh, drastic.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
Any closing remarks from you, Ms. Boone?
Yes, Your Honor.
Please say.
First, I'm only asking for this one hearing, which is a very
If I
important
was
hearing. I believe that the press is simply in it for ratings and publicity. My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online.
Sorry, I really wanted to say if I were just
That
a
was it.
defense attorney, this would be private. I just wanted to
This would
say
be
that.
moot.
Please, just say that.
which would be in that hearing.
So she doesn't get
I
privilege.
also, she was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because
Damn it, Hella!
What?
they would like to, again, in my opinion, for ratings and for publicity.
Me? I've been nice
It's one
to
hearing.
you.
There also is a solution that I believe. My
No,
understanding
she
was
says
that
your
this could be held
fan-
at the Orange County Sheriff's Department.
What?
She said something from Australia wrote her.
I didn't write her. What'd she say? What'd she say about Australia? Wait,
Maybe she's talking about the break dancer.
maybe.
Need to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do
Australia
not
said her hate
Publicity from
mail.
No. She said publicity from Australia.
No, hostile or negative publicity.
Oh,
Australia
not
being the
me.
most recently.
that's not me.
No,
That's not me.
maybe that's
Sarah,
Aussie
that's not
overlord.
me. Maybe it's Hayden. Damn you, Hayden.
She's too young for him.
Responsibility for anything Hayden does. Anyway, I'll have to send her a letter and just be like, look, I've been nice to you. I've given you lots of chances. I've got justice for Sarah Boone written here. Like people have
First
been
North
really
Korea,
mean to me
South
about
Korea.
it.
First South Korea, one of the Koreas, now Australia.
Wow.
They would like to, again, in my opinion, for ratings.
Write
and for
her a nice
publicity.
letter.
It's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court.
Oh, Murph,
I
don't
would
you know
like
about the
to
Dr.
properly
Pepper
prepare for this,
reference?
would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal
That was
in regards
eloquent.
for me to have privacy, expected privacy to a certain degree, and by
but
law,
unprepared.
to have this one hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can create the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
Are you serious?
Mr. J, yes, ma'am.
Forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
It's a freaking
Was
joke.
it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing.
Okay.
And I advised you that I needed to look at the
Wait.
law on it.
Okay, would they like to let the press in while she showers? Should they just let the press follow her around back to the jail and like just, let her let it be followed while she gets beat up and stuff. Like, how about that? How about that?
Why don't they just sit with her while she prepares her case and writes motions and
Yeah. Catch me outside. How about that, eh?
yeah.
This is stupid. God damn it.
And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or tenaciously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out, to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive. And I was not instructed by anyone in the court that that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told you on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drum drive, which contains the state digital evidence, the defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
You should have hired a lawyer. Oh, wait.
It was read to you as to what we would be doing today, and that we would be addressing the issue regarding the media's participation.
Like
and that's when you asked for the case law. And I said, I will give it to you. Absolutely.
He's talking down to her.
Yeah.
She's actually not stupid at all.
No.
I'm not ever sure of what it is that I'm supposed to be doing with,
She's trying.
I guess now.
She's
oral
really
and also in
trying.
writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me the day before yesterday and or could have been.
This
readily available
mail
on the internet.
situation has got to stop.
So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9.
Right, Murph?
If I need to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State? Okay.
From the state.
All right. Ms. Boone, any reason why Counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am.
Are you serious? She says, I need to be prepared. And he goes, that's an opinion you're entitled to. No, that's my right to have an opportunity to be prepared for my own murder trial. That is her right. That's not an opinion.
Yeah.
God damn it. You asshole.
The time to be a passive-aggressive dick judge is after she's convicted.
Yeah.
You want to censor her for all the shenanigans and BS she did up to this point? I don't think you should over necessarily, but that's when you at least can do it on the record.
My God.
Don't act like this.
Honestly, I'm really interested to hear this hearing in particular. He really is pushing it. And there's got to be lawyers out there who are commenting now who must be starting to notice that he is being completely unfair, that he's just pushing it far beyond anything that could be considered unbiased.
Yeah.
Lawyer, the other day, Peter Tragos, he was saying that the motions that she'd been putting forth to the court, a lot of the things that she'd been asking for are 100% fair and correct. And he was copying a lot of flack from his chat because they just hate her. They just hate her and go, she deserves this, she put herself there, la, 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 all the standard stuff, right? And I got to give it to Peter. Good. good. I'm pleased that finally we're starting to see some mainstream lawyers pushing back on what's going on here. But now it's going way too far. Now the situation with the mail is got to be fixed. It's got to be addressed. I'm waiting to hear. I'm hoping during this hearing that we're going to hear what's going on with the laptop. Is the laptop working now? She met with the investigator, Mr. Lane, the other day. I want to know what happened. Yeah. Oh, he comes in? Great.
I think I
want
saw
to know
him
what
earlier,
happened.
or later. Yeah.
Okay. I really want to know what's going on. Told you his chat has gone downhill. His chat's been garbage for ages. So yeah, I really want to know. And if lawyers start to push back in their chats, the internet's going to explode. But I hope that's what happens, because I mean, Sean's been talking recently about how this judge is acting like a dick, and I appreciate that. But most of the lawyers, even the defense attorneys who are on YouTube, have been just saying, fair enough, she deserves it, and this is amusing.
Yeah.
Well, no, it's not amusing anymore, guys.
In addition to what was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree. It has not been fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
Sure. When the defense attorney wants to do an evidence view, if we go to where the evidence is stored and the law enforcement agency, he or she can bring an investigator and an investigator to take photographs.
Come on, use your outdoor voice, sir.
We typically don't let the defense attorney.
Oh, isn't that raincoat, dude?
Himself, the CSI, who will be present as well.
Oh, yeah.
Investigator from the law enforcement agency will be the person to manipulate
He brought his jacket today.
And then you would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying the evidence, but a piece of clothing, the front, the back, you have the CSI turn it inside out, those sort of things.
Sir, the courtroom spent a lot of money for a microphone. Least you could do is use it.
That's like no way near it.
Between each piece of evidence, there's a new piece of cutting paper.
Oh, there we go.
Laid down, so there's
better.
examination for DNA.
Okay, no.
And this is basically how the process goes on. If it gets opened, it'll get resealed by the CSI right there in front of all of us, and the CSI will reseal the tape, re-put his or her initials over it, new date, so everybody will be on the same page about why it was opened, when it was opened, so on.
Thank you for that. If I may, is it closed or is it open to?
Yeah. People that are not involved with the case will not be there.
I can't move the captions.
You know, will my phone physically?
They keep moving back down.
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be photographed and physically examined. But in order for it to be turned on, it has to be done at a different location where there's something called a Faraday box or
Go
room
back up.
where electronics is supposed to not come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
If I can extract.
Brought
any
over
type
and
of
turned on. If I can extract any type of
Like we
information.
discussed in the last hearing,
So
that
like
would
we
be up to
discussed.
you to hire a digital forensic examiner.
To hire a digital forensic examiner.
That person, he or she could.
Then we could make that person here. She could.
Well, at least the captions are working.
All right. Then,
Yeah.
ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then, is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras.
Okay. All right. Fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was?
Of course.
Okay. And then once that's provided to the court, it can be filed and then the court will cancel the September 3rd hearing. Yes, ma'am.
And that is done by the state?
The
I
state will
don't really
prepare it.
understand what just happened.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it.
Thank you.
Okay.
I believe they're.
All right. Thank you, Mr. J, for providing an alternative solution.
Sorry. I know media. What are we talking about?
Yeah, I don't know. But
Can
the
someone
order.
please explain what just happened? That just went way over my head. Yeah, okay. And I don't want to have to watch it again. Scott, can you please explain? Hello, Sean
It was
Marie.
hard to hear.
It was really hard to hear, and yeah, okay. So, oh my God, John, thank you. Just a minute, I'll just read this chat. I listened to every letter she wrote to the judge, her attorneys, and she addressed them to the world also. This case is casing hell. Thank you, Sean Marie, for being here. Also, appreciate that. David, after the hearing regarding the media being there for her to review the discovery, they stipulated that they're going to review the discovery at a police department instead of court. Yeah, I caught that they didn't want to do it in, not the police department thing, but that they didn't want to do it in the courtroom. But how does that, is that all that they stipulated? Did they change the fact that the media might not be there or not?
Oh, so they've stipulated that they're going to review the discovery at a police department instead of court. So in the police department, the media wouldn't be there.
Why would that make a difference to whether the media could be there? Couldn't they be in a police department?
Okay, so the evidence you're hearing off-site, so the cameras won't be there.
Why? Why could they not be there? Because he's already ruled that media could be there.
Well, both sides, I think, have stipulated that they're going to change the location so it's not in court, so the media will not be there.
I don't understand how one thing equals another. Doesn't make any sense to me.
Unless it's an agreement.
Just because they moved it.
Well, yeah.
I know that, yeah, I know it's, oh, well, it's, what do you mean it's cancelled? It's just moved. I know it probably changed to a different date because they were talking about the date not being the same.
Okay. So
it's so complicated.
Not being held in court, which would make it open to the public. At the sheriff's office, it would be private. Oh, because the prosecutor knows that it's a bunch of BS that the media is going to be there watching her review her discovery and preparing trial.
Oh, so the prosecutor doesn't want it either.
So they're trying to cover their ass. Okay.
Ah, I see. Right. So the prosecutor stepped in and gone, hey, you want to do it over here?
Okay.
Because
this is odd.
Isn't this odd?
Yeah.
Isn't this odd?
Well, and yeah, maybe the state isn't very confident in some of the judges' rulings then.
Well, isn't that interesting? Because the judge really shouldn't have entertained this at all. To be fair, I mean, just because the media put this, someone from the media came along and asked for this, and then came to court, and she didn't make an excellent argument back. Really, it wasn't a fantastic argument. Doesn't mean he shouldn't have overruled it. So the prosecutors have come along and challenged it and said, "Oh, we'll have it over here." What's this? Yes, they stipulated to getting exactly what Boone wanted. Yes, exactly, because that's what it should have been all along. What it should have been all along. So what's the judge doing, for goodness sake? He should have just gone with Boone all along, but she didn't make a great argument.
Well, that is true. She made a really crappy argument.
Yeah.
I think the state is trying to kind of bail her out at this point to protect the record.
I think they're kind of bailing themselves out as well.
Yeah,
they don't want it to be
out. Yeah.
They don't want it to be public either.
Well, they don't want it overturned on appeal. So
kind of, but it's like it's an evidentiary viewing, right? So it's evidence viewing. They don't want
they've already
viewing
seen
all this stuff publicly. They've seen the evidence, but they don't want her pulling things out in front of cameras and stuff and going, "Oh, that's not what it looked like before. I don't recognize that." And that can look bad for the state, right? So this is not a thing that's sort of part of their game plan. Yeah, anything could happen. I'm just imagining them thinking about the repercussions of her handling all this evidence in front of the press. This isn't good. And it's not normal. That doesn't usually happen. Yeah, right. Okay, we have gifted memberships. And thank you, David, for helping explain all that. It doesn't happen. Their hearing on September 3 is a backup with media coverage. Yes. Okay. Thank you. We have gifted memberships. John, 5 excited owners gifted membership. Thank you so much. You're a legend. You noticed there were greys. Out with the greys. We are racist towards greys. No offense, greys. But we want to turn you green.
Yes.
We want to turn you green, one green at a time. And green is good. And Snibbles with the 5 excited utterance memberships, helping rid the chat of greys, one green at a time. Love you, Snibbles. You're awesome. Can we read them out, please, Dolly?
Yes, I can. Jihad 67, Crystal Lanford, C. Suda, Ami, Ohio, BL Blazy. Beautiful Waterfall was gifted a membership. Jan Kunot, Christy Nevada, Darlene, and Jeff were all gifted memberships.
Yay, welcome. If you are new to being a member, you might not know that you can go to the membership tab and go to perks and click on the Discord link, and you can come straight into our wonderful land of Dali Hella, where everything's wonderful and we can chat freely. And there's all sorts of excellent channels in there to have fun. MLS God of Law is Salvador a pet. Sorry for your loss.
No, he was teasing with me, and he was talking to me. And he was just screwing with me, but that was fun.
All right, that's funny. Oh dear. That's awesome. Thank you so much for the gift of memberships, guys. Okay, let's get back into it.
Solution. Ma'am, I wanted to go back and address your request for
Marie,
freedom of movement
welcome.
motion that we addressed last week, and your desire to use a stun cuff. I understand that a representative from the Public Defender's Office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person, it is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
God,
It's
women
something that
never
you need
know
to
what
consider.
wear.
I have.
If you're wearing pants, they obviously cannot see it. If you're wearing a skirt,
What the
they
hell?
can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option,
But I look
if you
so
do not like
good in a
either of those,
skirt.
is the parties
Please
will
don't clip
remain, you'll
that.
be hands-free, as we discussed, but you'll have the leg restraints like you have today. And
Right.
everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing statements, closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated
Yeah,
in
we've seen it.
the majority, if not all, of the hearings that this court has
Yeah.
had with you.
Is the
Mhm.
court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings.
You know
in
what she's
regards
asking.
to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
How about yes?
So if I may, please, my options are pants hiding the stun cuff, or a skirt with it being visible, or I am able to sit here at the council's table with leg chains on and no one is able to move except for here at the council's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so Ms. Boone is aware fully of what options are.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
We have gone through the entire audit as well as our.
Who are you?
For what we have. As it stands right now, unless we have any donations to the side that have to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, well, we do have some shirts, but for in terms of skirts versus pants versus the dress, that is everything we have, that would fit in this size range. So I just wanted that to be aware so that, if Ms. Boone is making any sort of decision, she understands the limitations in terms of what we have to be able to provide.
Okay, ma'am, did you have the opportunity to hear what Ms. Glick said?
I
Do
did.
you have any
No.
questions for her?
If you could please repeat what it is that you will have available, the numbers.
8 pairs of pants, 2 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Glick regarding the clothing that the public defender is endeavoring to provide for you?
Oh, she's the
And if I
public
do come
defender.
to the decision, I can't always have someone externally bring something into me.
Absolutely, you can always have someone provide something in your personal property at the visitation center. Which I described across the-
Yeah.
on the-
It's incredibly hard to hear her. She's talking about the kind of clothes that's available to her. And she's also saying that if Sarah has
Any other
someone
questions for
who
her?
can provide clothes
Can Ms. Click
to bring in, that's
be
fine too.
excused?
Yes, thank you.
Thank you, ma'am.
Murphy Turpy
The
with the
next
5
issue that I
excited
wanted to address
utterance
was the
memberships. Thank
review
you, love.
of the digital discovery. Ma'am,
What's
Mr.
up?
Lane was provided at our last hearing on the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence, and digital transcripts of the depositions of Detectives Chelsea Kopsel and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
Did
Okay, what was provided to you, if anything, at that meeting?
what he and I did.
What was provided to you? What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay, all right. And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's
Okay,
exhibit list?
I can't wait to hear about this. Thank you so much, Murphy Turfy. You are a great friend. It's so great to have
Yes.
you in chat. And thank you for the 5 memberships. Welcome to Mark Gato, Marcy Albanati, Lacey P, RX Girl, and Chrissy T009. We are removing all the grays one at a time. We are going green. Justice for greens. No justice for grays. 21 is still grey. Thank you so much. Yes. Love you muchly. Yeah. All right, let's keep going.
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding also in order to meet the deadline for the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than one.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay, you did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay, all right. Okay.
It's on our to-do list.
Oops. Sorry. Whoops. Sorry. Boomer.
Ma'am, Mr. Lane also took possession of the hard copies. Have those been provided to you?
They have. They were waiting at the dorm for me upon my return of the last hearing.
Okay, and where are they currently?
They're located at my bunk area.
Okay, and what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay,
Right.
all right.
So it was
Are they in
possible
some
for them
type
to
of
be
bag,
there.
or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay, all right.
After all that.
Do you understand that, you've told me that you live in a female dormitory with limited privacy. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but do you understand that that risk exists?
Of course.
Okay, do you understand that there's a risk that those items could disappear?
I understand.
Okay, all right.
Better than not having them.
Do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer also for an extra security measure.
Okay, all right. I see that we'd have Investigator Lane here. Sir, if you can come out. Madam Clerk's going to
I'm
go ahead and swear you in.
amazed. How much argument and time did it actually take? I can't believe that she actually got the boxes. She got the boxes. Win for Sarah. I did not think she was going to get those boxes. She managed to get the boxes at her bunk. I didn't think she was going to get the boxes of documents anywhere near that jail because they said they had nowhere to store them. She couldn't have them. I don't know. She's got them at her bunk, and fair enough. They could get stolen. They could be looked at, but it's better than not having them. It's better than not having them. Wow. Okay, the box saga's not quite over yet. Maybe not beautiful waterfall. Okay, thank you for warning me. Righto. I think this Mr. Lane, he's a bit of a knight in shining armor for Sarah. He helps her.
I do.
Sir, good afternoon. Can you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right, thank you, sir. I did see that your notice that you provided regarding the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the depositions of the 2 detectives.
That's correct.
Okay, all right, sir. And when you met with Ms. Boone on Saturday, again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay.
If there is, I will be happy to let you know.
All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane? Ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives,
Correct, based on what was teed up for hearing today, which was addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm still trying to schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Your Honor,
All right, thanks, sir. Appreciate you. Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative
right,
from
summary.
the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail. I have a Administrative Sergeant De Jesus. on the link.
Jesus. Hello.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie De Jesus with me.
All right, very good.
I also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant De Jesus, if you could please, I only see you, Captain. If Sergeant De Jesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
What have they got to say?
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie De Jesus. Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do, and we can proceed with the 7 different items that she has requested. So,
So with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m. and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes.
All right. Do you have any questions regarding that extension?
I do not.
Okay. Is that acceptable?
Very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
Stabby, stabby.
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why other than the fact that the assumption could be made that it could be feeded to something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear other than those reasons why I cannot have those as well.
To the extent you're able to answer that question.
Obviously there's safety issues, and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem. It sounds like to me is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the corrections department position with regard to the USB drives?
Jesus.
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way.
Okay, I've got a solution. So this drawer that she's got, that's got a key or a lock, why don't they lock it in the drawer and take the key away from her and only open it up to let her access the USB drives when she's being let out to use the laptop? Like actually pick them up for her and bring them with her to use them with the laptop, right? Not like give her the key. So that's her lockup, but she can't have access to it because there's something in there that could be used as a weapon. Just thinking outside the box.
That may affect security, and it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shebbenell.
One more time, please.
Shebbenell.
Thank you.
With regard to the third request, is to a classroom, Captain DiGiovanni?
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it is not the maximum dorm any longer.
That's correct.
Yeah. Maybe she
And
needs
I'm
to
unable
take
to
it.
utilize the classroom for an hour or two per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the two classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation to have just for fresh air? How is that? I'm not understanding specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours.
Take it.
And instead of having to move items from a housing area into a classroom, where the officer may have line of sight. I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal dayroom time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to the County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there, in order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours? Captain?
Judge, I'm not objecting to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits.
She asked for limits. She said limits.
So again, I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program, we've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response.
Oh, please.
Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are correct. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that's diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard, and we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
They're taking Sarah's box fort too?
Oh my God.
Ma'am, do you have any questions regarding
First
Captain
Brooks, now
Giovanni's?
Sarah?
and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard?
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Ms. Boone.
Can we just like call it for a second and like come back to reality for like just a moment? This woman has not been convicted of anything.
True.
Right. Can we just like just reality check? She's actually not being convicted of anything at all. Right? So this whole idea of like whether she should go to solitary, whether she should get a phone, whether she should get internet access, the fact that she's having to defend herself, all this stuff, she's sitting there with shackles on her, a stun cuff, etc. She deserves all this, blah, 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 blah.
Yeah.
All right, I get it. She's headed for trial, but she has not been convicted of anything. And she's trying her best. She's being very calm in this situation. This is driving me berserk. This is driving me berserk. I can't believe it. Fire hazard, my ass.
Yeah, she's not like
you're
Bradley
right.
Young.
Yeah. Yeah. It's the most ridiculous courtroom in the world. And I call bull puckery on this fire hazard claim. If there's fire, shit will burn like sheets. 100%. 100%. She's right. She needs to be able to call people. She needs the internet. This whole sending mail down the street and it not being received in time for her to go to her hearing. So she can't even look at it and digest the information before she's at her hearing. And then these jail officers are on this Zoom call and they haven't even looked at the information in order to respond properly. Right? So they're all like, oh, we'd have to refer to legal counsel in order to come back to you on that. Why haven't you then? Why haven't you then? Why are you there on a Zoom call looking at the request and going, oh, well, I have to come back to you on that. I have to refer to legal counsel. Her trial is less than 2 months away. It's 1.5 months away. This is ridiculous. Sorry, rant over.
Okay. Am I able to proceed?
You can.
Thank you. So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access, if I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do so by having this where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott. I mean, I'll chip in with the legal piece. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates, and all those policies are in place for a reason.
That's
somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
And it's not. And that's the problem. And the court knows that. The court knows that. It's not a constitutional violation. The jail doesn't have to do anything. And they can say, oh, she's asking for things that are over and above, because the jail is not infringing on her constitutional rights. The court can wipe their hands of it and go, well, we've covered our ass, and the jail doesn't have to do anything to help you. So therefore, there's nothing that's going to sully the record.
Yeah.
Nothing. So yeah.
Do you want an
And
appeal?
guys,
This is
guys,
how
I
you
get
get
it.
appeals.
I know Kat Maxson. I know that she's been charged and she's an inmate. But here's the thing. I would think that the court would be going overboard to try and ensure that she has every opportunity to be very well prepared, making as many allowances as possible to give her some sort of latitude. Yet Judge Kraynick is throwing her to the dogs, I guess, in this instance. Like, I feel that he knows very well that this is going to happen. He knows very well that there's 2 months and the jail doesn't have to do anything. They don't have to do anything. They can make it as difficult as they like for her, or just not bother. Just not bother. So, yeah. Sorry. I just had to have a rant because I just felt crap about that situation. Just because we aren't making the allowances we want them to make, doesn't mean they aren't making allowances. Sure. Yeah, since this wasn't her choice to proceed per se. Oh, I wish we could ask Gosney. I think this is probably the last thing on his mind right now. Anyway.
Is that a position, Counselor, that you're taking today? Because Captain Giovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, legally she's allowed access to the court and all the other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with her phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that question.
Penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case in the successful outcome that they were hoping for by being provided simply papers and pens.
A good question. Yeah, how did they do it without it?
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
They're simply requests. And I'm not sure who
Not
it might be
demands.
that could answer my question, please, in regards to what prior or present other pro se
very
defendants and
passe.
inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through, that are there right now, that have come through the jail, and they get standard treatment. And she wants a lot of them to go over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples if need be as to what people have received in the past, and it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously.
I don't believe that for a goddamn second. So he's saying that they've had pro se defendants in the jail before and they haven't asked for working internet or a laptop that has goddamn MS Word on it or a phone that works.
Yeah.
Bullshit. I call bullshit. Garbage. When was this? Was this 1995?
Yeah.
I reckon that was 1995. All right, I want to know. Because, or he just hasn't even had a pro se defendant in there and he's just like, oh, well, yeah, I think we did. Perjury.
On the record, with regard to your request to hold the USB drives in your own personal lockup for the reasons identified by counsel Chevenel, it's a matter of security and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, he can do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Yeah, it's basically the Florida Model Jail Standard 7.12. The officer in charge of designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge of designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Ms. Boone's letter, if you give me one moment. In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I'm willing to see what she's going to purge and send to property, but at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified. I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above
don't say that word.
we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions?
And
no, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that can be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving and delivering anything to the property
She's got a
department.
second case, family law case.
Solution of me trying to purge what I can specifically to be specifically
Is she
removed
related
from
to
the jail
Rakeda?
completely by a friend who can come and pick that up. I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there, where I already have everything in the boxes in the one bag already being occupied.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today, is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Judge, may I say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Yep.
This is just
I would have to
retarded.
figure that out for the voluminous amount of paperwork that are contained in those two boxes.
So I don't like using that
And
word.
there's
but
no
I
way
couldn't.
to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those two fire retardant bags with my hard copy discovery enclosed in those. If I could please do so.
Mr. Charbonneau,
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in another property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
I could provide the third fire retardant bag, but it's the encroachment into another inmate's area. It's a limited space.
It's encroaching.
But the cardboard box can't remain.
Growing.
And Judge, if you
Brooks
recall my
2.0.
request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very reason.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized. But she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
That's up to her if she wants paper or not. That's fine.
It was never my
She
decision
could
to have
paper
anything
cut herself.
digitized in the first place, and nonetheless, it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that on the USB drives.
Have you
I
tried
learned
to
about
delete
that.
System
That being
32?
not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk. I have that as plan B when plan A is closed.
Judge, if I might be able to offer a resolution here.
Okay.
Was the discovery that Ms. Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
Would Ms. Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ooh.
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone,
It is a mass amount of paper.
are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have content inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet because of waiting for information for this. But I can further explore once I return back to the dorm.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida Model Jail Standards, to reduce the amount of paper clutter in all living spaces. It's not specific to just your housing unit.
Thank you.
Captain DiGiovanni, now can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or a string, so that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes is the fire risk, because it is not authorized or recognized as a fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag, and again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out. I'm amenable. I'm amenable to her keeping her documentation. I'm not looking to take anything away from her,
And
but
all
it
the
has
letters
to be
Hella wrote
in
her?
accordance with fire marshal and policy.
I understand, and I would be happy to comply with the extra bag and the manila envelopes for separators in regards to that.
So, ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is, if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some type elastic, something to be able to bind the paperwork together. Is that a possibility?
Now
I
you
didn't hear
want
the question.
bands?
You may have to
God.
speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed,
Yes,
to have
beautiful
a type of rubber
form.
band or some kind of elastic in order to bind?
No,
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So when you pick that up, everything goes in the middle. So there's no type of, there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope and that manila envelope keep paper in order.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
Not in regards to the hard copies, no.
Okay, all right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Shebamel?
Yes.
Could you please provide me with the protocol or policy that you all have, a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Yes, are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are
want me to do it for you,
accusing
Sarah?
me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or a process in, if you have a pro se packet, like JAC has a pro se packet. Does Orange County provide something like that?
Oh, she wants one of those.
I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
Yes, please. Captain, I would be responding to you in regards to that or following up with you, or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shebamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to? Because I am in desperate need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and
Please call me Counselor
advantage
Boone.
as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one way, or every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed with you, mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through the United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
Ma'am, for the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your
You're entitled to that
representation
opinion.
of yourself. Anything else that we need to address today, ma'am?
How about
I
you put it
have
on
a
the
motion that I
record?
would like to submit, please.
Okay. Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
Look, I just feel like,
In regards to what?
hang on. So she stated clearly that she's unable to be prepared in time. So wouldn't that be? Wouldn't the judge? Isn't that, as a pro se defendant, wouldn't the judge take that as being an oral motion for a continuance by a pro se defendant?
Well, she already tried it, just not officially, like in a
I know,
motion.
but she's a pro se defendant.
know.
Like, she doesn't know how to do it.
You're not asking case strategy about the mail either. So it's like,
I know, but like, give her a hand. Come on.
just,
Oh, dear me.
you know how
Asking
embarrassing
questions
it's,
about the mail is not legal advice. Yes, I know.
you know how embarrassing it must be, it would be to be overturned as a judge for not protecting a pro se litigant's constitutional rights.
How embarrassing it would be.
Yeah.
Yeah, except it's Sarah Boone and no one cares.
Well, judges don't like being overturned. And I feel like that's possible here.
Oh,
Anyways.
look, we can only hope. We can only hope.
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shebamal.
Okay, are they free to leave?
Very polite.
She seems so nice.
All right, thank you all very much.
That was,
Ma'am, you made reference to
classy.
another motion or something else that you had.
Yes, I have a motion.
Okay, if you can hand it to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it and then I will.
Murph says, perhaps the judge's emotions are getting the best of him and now he has a strong negative bias towards her. Yes, like the rest of the country.
Ma'am, give me a moment to take a look at this.
But he's the judge. Yeah, I wonder if this friend that she has is the reason she doesn't want to go to solitary. And if it's a friend who is helping her with the legal stuff. That's actually a really good point. She needs this friend.
Court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense. State, I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today. I will have to coordinate a hearing with JICS to have this heard because this is something that involves them. And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Okay, thank you.
So the court will file this in the court file and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week.
She needs
Anything else,
internet
ma'am?
and a phone.
Just to confirm,
working
please,
laptop.
for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, State?
Nothing, State.
Ma'am, anything else?
No, Your Honor.
All right.
Really?
We'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
Forgive me. In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
Good.
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail?
Good
I
question.
can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just
Excellent.
so for recap purposes, with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right, anything else?
Okay. Young. So she asked if Mr. Lane, who is her investigator, can be given notice of the next hearing before the mail, basically. So can Mr. Lane be given notice so that she can hear about it through him before she has to wait for the mail order? So it's the letter in the mail, basically, which takes days and days and days. And then she has to, like, even if she does receive it before the hearing, she's got no time to sort of look at it and disseminate it and work out what her strategy is going to be. So that's a really good move by her to ask for that. Mr. Lane is on her side. So he's the guy from Prison Break. And so he's her investigator. And what I've learned is that pro se defendants get one thing, and that is an investigator. So basically like a researcher, they contact people, they look into avenues of inquiry. They're not a lawyer, but they're sort of like a helper. And yeah, the JAC did approve some extra funding for him. So up to from $5,000 to $10,000 when she went pro se. And he seems to really be on her side. That's his job. And he went and helped her with her laptop the other day. And yeah, so I think he might have had something to do with this request that she's just put forth about the neuropsychologist. And so Scott has said, a neuropsychologist is an expert in how brain injuries and conditions affect your behavior, mood, and thinking skills. Very interesting. I'm interested to get experts. She's trying to get experts, and this could be a good case on her part. Well, yeah. Look, I don't think she's got much hope against the very large amount of resources of the state, but we will see. We will see. I really want to see her put on a good fight. I really do. Yeah. She set up Bill Lane as her primary contact with the court. Well, and the court asked her, advised her to, I suppose, without giving legal advice, said that he has internet access, he can contact people for you. Well, that's just great, but she hasn't got unlimited access to him. She only gets to see him occasionally. And I suppose, she can call him, I guess, collect. I wonder whether or not there's privilege on those phone calls, because he's not her attorney.
I believe he does have privilege.
You would think.
And so in theory, the jail he would invoke privilege on the call and the jail could not continue to listen to.
Right. She can call him daily. Really beautiful waterfall. I love how you know all this stuff. Claps to beautiful waterfall. And thank you also for
Encyclopedic
all the
qualifier.
she's so great. The updates throughout the day have been fantastic as well. She may give the state a run for their money. I hope so, because they deserve it. They deserve it. Yeah, their calls would be private. I hope so too. And yeah, Billy Lane is a cool name. Prison Break's a bit of a funny name. Apparently, is there a TV show in the US called Prison Break?
Yeah.
Because apparently the logo is like a ripoff of the TV show. Yeah. That's funny. Okay, I gotta get moving because I've got another stream in like 40 minutes and I gotta get prepared for it. So the Koberger cover-up at 9 p.m. Eastern. Yes. So the Koberger cover-up is the first in a series of discussions with people I've found on my travels around the interwebs, people who are very knowledgeable about the case. And the first person I am bringing on is Kathy from the Indie Zone. She is a podcaster and researcher, and she knows the Koberger documents back to front. And if you've ever had a look on the Idaho Judicial Cases website at all of the documents, there are gazillions of them and they're very complex. She knows all about the sealing of the documents, and yes, so much information about Idaho versus Koberger is sealed from the public. She is going to talk a lot about that, but also there's been a document drop in the last day, just in time for this stream, and that is the state's opposition or you call it motion to oppose the change of venue for the trial, which is next year. And it's a bunch of malarkey, if you ask me. Malarkey. So we're going to talk about that too. Join us in 40 minutes for that one. It's going to be an excellent conversation. I can't wait to meet her online and talk to her. She's a font of knowledge. Not that kind of font. A font of knowledge. So yeah, that's in 40 minutes. I got to go get ready. Thank you, everybody. And thank you, all of you, for the gifted memberships, those UK gifted memberships. John, Schnivels, Mershterp, and Shelmarie, thank you for becoming a member. I really appreciate that, your support. Everyone for being here too. I know it's out of the ordinary to be someone who has a different opinion on this one. There's so much hate for Sarah Boone out there.
Yes.
But I just feel like she's getting a raw deal. And yeah, she's responsible for the death of George. But whether or not it is murder or manslaughter is the difference between her son having a mum growing up or not, actually. And people are just so willing to just throw her away. But I think there's more to this. And justice is for everybody. Due process is for everybody. Without that, then might as well just have no justice system and throw everyone away. Not intentional. Oh, you want a not intentional before we go. Hang on. Where is it? You get one because you got it?
Yep. Reach around.
Oops. No, not reach around.
Not intentional.
There you go. Alrighty. And on the way out, we'll do this. Invest in the oppressed.
She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud.